Your Honour, I appear on behalf of the applicant and claimant in this matter, Mr. Liu. This is an application on behalf of the claimant for an interim injunction to prevent the defendant from harassing the claimant pursuant to CPR 25.1.1a. Your Honour, I will be relying on the following documents, which are laid out in paragraph 2 of my skeleton argument. They are the witness statement of Walter Liu, dated the 9th of March 2020, the draft particulars of claim, the draft order, as well as my own skeleton argument, dated the 10th of March 2020. May I ask if Your Honour has received these documents and had an opportunity to read them? I am grateful, Your Honour. Given the urgency of this application, I anticipate that Your Honour will not have been able to read these documents in detail. So perhaps if I may begin with a brief summary of the facts to provide assistance to the court in this matter. These facts are laid out in paragraphs 3 through to 6 of my skeleton argument. Mr. Liu is the director of Liu Valley Health Limited, which operates health clubs. Approximately 2 years ago, the defendant was employed at one of these health clubs, Liu Valley Spa. Mr. Liu terminated the defendant's employment following an altercation when the defendant swore at Mr. Liu and spoke to him unpleasantly. The defendant did not respond well to this decision and became aggressive and had to be escorted off the premises by security. Since then, there have been multiple incidents where the defendant has harassed Mr. Liu and made threats to him, as well as more recently doing the same to Mr. Liu's son, Peter. Many of these incidents have taken place at the Wetherspoons public house in Clara C. Your Honour, I am now at paragraph 7 of my skeleton argument. Your Honour may be concerned by the lack of formal notice for this application, and will have observed that the defendant is not present nor represented at this hearing. Your Honour, the urgency of this application is clear, as Mr. Liu and his son remain at a continuing risk of harm. If Your Honour looks to the witness statement of Walter Liu, you will see at the end of paragraph 37 in that statement that he says, "I am worried that unless I have immediate protection, both myself and my son are likely to be subjected to further threats and violence from Mageddon." Your Honour, this is in light of the fact that the defendant has recently been outside Mr. Liu's family home and continues to make threats to him and to his son. Your Honour, the police involvement on multiple occasions demonstrates that there is a clear and genuine threat here, and I urge the court to look on this as justifying the lack of formal notice given the clear urgency in the matter here today. Your Honour, nonetheless, several attempts have been made to give informal notice to the defendant, which the court should look favourably on. For example, Your Honour, a voicemail message has been left on what appeared to be the defendant's answer phone, informing him of today's hearing. Furthermore, the witness statement of Walter Liu has been personally delivered to the address of his that was held on file. Your Honour, I therefore submit that in the circumstances all reasonable steps have been taken to informally notify the defendant of this hearing. Your Honour, moving now to paragraph 9 in my skeleton argument, the applicant is well aware of the duty of full and frank disclosure that is required in cases where formal notice has not been given. Your Honour, in light of this, the court should be aware of an incident that occurred during the defendant's employment, in which Mr. Liu physically lashed out at him following an argument in which the defendant had indicated that he had been sleeping with Mr. Liu's wife. Your Honour, I am aware of no other such incidents, however, I'm bringing it to the court's attention in line with this duty of disclosure. Nonetheless, I do submit in the overall context of the application, it is clear that it is Mr. Liu and his son that are the ones at risk of threatening behaviour. Your Honour, moving now to the relevant applicable law for granting an interim injunction, which can be found in CPR 25. If Your Honour turns to page 825 in Volume 1 of the White Book, you will see that pursuant to CPR 25.2b, that an injunction may only be granted before a claim is made if the matter is urgent or otherwise desirable in the interests of justice. Your Honour, I have already addressed the Court on the urgency of this application. Your Honour has also already had sight of the draft particulars of claim, and Mr. Liu undertakes to issue the claim promptly following this hearing. I therefore submit that the injunction should still be granted, even though the claim has not been issued. Your Honour, in applying CPR 25, as I'm sure you are well aware, there are guiding principles established by the case of American Cyanamid and Ethicon Limited, which Your Honour will see on page 2933 of Volume 2 of the White Book, as well as being laid out in paragraph 11 of my own skeleton argument. The case stipulates a three-part test. Firstly, is there a serious question to be tried? Secondly, would damages be an adequate remedy? And thirdly, where does the balance of convenience lie? Your Honour, these three elements will form the basis of my submissions. Your Honour, moving to paragraph 12 in my skeleton argument, I will address the Court on the first limb of the test, whether there is a serious question to be tried. If Your Honour looks to page 2934 in Volume 2 of the White Book, to point 10, you will see that American Cyanamid sets a low threshold for this element of the test, stipulating that the Court must be satisfied that the claim is not frivolous or vexatious. In my respectful submission, Your Honour, the case before the Court today quite easily overcomes this low hurdle. I submit that there is a serious question to be tried, as there is a genuine cause of action under the Protection from Harassment Act. The actions of the defendant are quite clearly harassment and would be such that he would know that they amounted to harassment. If Your Honour looks to the witness statement of Walter Liu, to paragraph 11, you will see examples given of the direct threats made by the defendant, such as, "I'm going to teach you a lesson," and "I'm going to do you when I get a fucking chance." Your Honour, clearly this is threatening behaviour. Now, to draw Your Honour's attention to a more recent incident, if you look to paragraph 26 in the witness statement of Walter Liu, Your Honour will see a description of an incident that occurred outside the Wetherspoons public house on the 2nd of March. Mr. Liu explains, "The defendant knocked me to the ground with his fists and head, also using his entire body weight. I was then subjected to an approximately 30-second barrage of violence from him, including punches and kicks." Your Honour, clearly there is a great deal of violence and threatening behaviour going on the part of the defendant in this case, and I submit that this is sufficient to amount to harassment. Your Honour, I also submit that the three incidents towards Mr. Liu's son, Peter, are sufficient to amount to a course of conduct of harassment. If Your Honour turns to paragraph 20 in the witness statement of Walter Liu, you will see an example of one of these incidents. If you may just take a moment, Your Honour, to read paragraph 20 to yourself. I am grateful, Your Honour. In my submission, this conduct therefore brings both Mr. Liu and his son within the parameters of this Act, as they have both been harassed by the defendant. Therefore, in my respectful submission, there is a serious question to be tried here, as there is sufficient evidence to overcome the low hurdle that is set by the first element of this test, and I submit, Your Honour, that this goes in favour of granting the injunction. Your Honour, moving now to paragraph 16 in my skeleton argument, I will address the Court on the adequacy of damages, firstly to the claimant. In my respectful submission, Your Honour, if an injunction were not granted, damages would not be an adequate remedy to Mr. Liu. The continuing risk to his safety and well-being, as well as to that of his son, is not something that can adequately be quantified. In any event, We are unaware of the defendant's financial position, so could not be satisfied that he would be in a position to pay. Overall, I therefore submit that damages would not be an adequate remedy to Mr. Liu. Alternatively, Your Honour, and now at paragraph 19 in my skeleton argument, I submit that damages would be an adequate remedy to compensate the defendant if it were later determined that the injunction had been wrongly granted. Furthermore, Your Honour, Mr. Liu is prepared to give the necessary undertaking as to damages. This would be from the company Ray Kitten Limited that he runs with his wife. Those instructing me have had sight of signed authority by both him and his wife, who are the only directors of that company, who both authorise this undertaking being made from the company. Your Honour, I therefore submit that damages would not be an adequate remedy to the claimant, but would be adequate and available as a remedy to the defendant. In light of this, I ask Your Honour to grant the interim injunction today. Your Honour, now at paragraph 22 in my skeleton argument, I will address the court on the third element of the American cyanamide test, which is the balance of convenience. If you look to page 2937 in volume 2 of the White Book, to section 1512, you will see about 2/3 of the way through that second paragraph the case of National Commercial Bank Jamaica Limited and Olint Corp Limited. This case states that the court has to engage in trying to predict whether granting or withholding an injunction is more or less likely to cause irremediable prejudice. Your Honour, I submit that much greater prejudice would be caused to Mr. Liu if the injunction were not granted than would be caused to the defendant if it were granted. If the injunction is not granted, then Mr. Liu remains at a continuing risk of further harassment and violence from the defendant. Your Honour, the recent events demonstrate that this behaviour is likely to continue without a court order. On the other hand, Your Honour, by granting the injunction, the defendant would only be prevented from harassing or communicating with Mr. Liu and from coming within 100 metres of his property or Liu Valley Health Spa. Your Honour, this would be fairly minor and in the scheme of the case would be far less prejudicial than to allow Mr. Liu to continue to be harassed. Your Honour, I therefore submit that the balance of convenience test clearly lies in favour of granting this injunction. Finally, Your Honour, at paragraph 26 in my skeleton argument, if you consider the factors to still be evenly balanced, then Your Honour should favour preserving the status quo. I urge the court to preserve the status quo from before the harassment began, as no new status quo has been established. Mr. Liu has not acquiesced in the state of affairs, as he has made many previous attempts to stop this behaviour, for example by reporting the matter to the police. In light of this, I urge the court to preserve the status quo that existed before the defendant began harassing Mr. Liu. Clearly, this goes in favour of granting the injunction. Your Honour, in conclusion and in light of my submissions, I submit that an interim injunction should be granted here today to prevent the defendant from harassing Mr. Liu. There is clearly a serious question to be tried. Furthermore, damages would not be an adequate remedy to Mr. Liu, however would be adequate and available as a remedy for the defendant. Finally, the balance of convenience lies in favour of granting this injunction. Your Honour, unless I can be of any further assistance, then those are my submissions.